What happens when an ex-employee demands benefits without a signed contract? In my usual legal practice, I primarily handle solicitor work, drafting contracts, advising on legal obligations, helping clients negotiate terms, and ensuring that deals are sound and compliant. It's the kind of work that, if done right, preempts problems and keeps everyone out of the court. Because of this, I don't often get the kind of gotcha moments that litigators experience when they cross-examine a witness or deliver a decisive argument before a judge. But once in a while, a situation arises that not only brings me into the litigation arena, but also allows me to deliver a particularly satisfying shutdown of an opposing party's unreasonable claims. One such instance involved a longtime client of mine, a business owner who had been sued by a former would-be employee. Let's call this individual Kevin. My client runs a growing company and had decided to bring Kevin on board in a sort of right-hand role. The arrangement, at least initially, was straightforward. Kevin would work for 6 weeks at a slightly lower wage than what he would ultimately earn. After that trial period, they would finalize an employment contract at the agreed-upon rate, along with a clear set of duties, responsibilities, and some standard clauses like non-compete and confidentiality provisions. For about 5 weeks, Kevin worked without any major issues. He performed decently enough, and there was no immediate cause for alarm. As the 6-week mark approached, my client prepared the official employment contract for Kevin to sign. The terms were what had been verbally agreed upon. The agreed-upon duties and responsibilities spelled out clearly: a reasonable salary, non-compete and confidentiality clauses to protect the company, and all the standard conditions one would expect in a well-structured employment. But when Kevin returned the document, he had taken substantial liberties. Instead of the small tweaks he had claimed to want, Kevin had attempted a wholesale rewrite of them. He had removed the entire duties and responsibilities section, effectively erasing any defined job description. He had cut out the non-compete and confidentiality clauses that were crucial for the company's protection. On top of that, he had unilaterally increased the salary beyond what had been agreed and had added a list of additional benefits that my client never consented to. My client was understandably appalled. This wasn't a minor negotiation point. It was a blatant attempt to hijack the terms they had discussed and to secure a far sweeter deal than anything originally offered. The owner calmly but firmly told Kevin that he could not accept these self-serving changes. Kevin was given the choice: sign the original contract as agreed, or seek employment elsewhere. Kevin chose to walk away from the job. Normally, that would be the end of it, but Kevin had other ideas. He decided to sue my client. In his lawsuit, he demanded payment for the full 6-week trial period, which had already been paid in full, an additional 2 weeks' pay in lieu of notice, and a staggering 5 weeks of vacation pay. The demands were baseless, especially given that no finalized contract had ever been signed, and the relationship had ended before any new terms were formally agreed upon. When the matter went before the judge, I took the lead on my client's behalf. Kevin's claims were audacious, to say the least. Employment legislation in most jurisdictions is relatively clear about what obligations exist in the absence of a signed contract. Kevin had never secured the enhanced terms he wrote in himself, and he certainly wasn't entitled to the extended benefits he was now claiming. He seemed to believe that by simply having worked a partial trial period under a verbal understanding, he could conjure up all manner of entitlements from thin air. In the courtroom, I had the opportunity to address Kevin directly, and by extension, the judge, with the straightforward logic of the law. I explained that Kevin was not entitled to anything beyond what had already been paid to him. The only avenue through which Kevin could have claimed additional wages, notice pay, or extended vacation time would have been if he had signed the original, unaltered contract that laid out these benefits clearly and legally. Since he refused and walked away, no such contract existed. Without it, Kevin's claims were pure fiction. The judge, seeing the situation for what it was, dismissed Kevin's case in its entirety. Not only did Kevin fail to prove any entitlement, but the judge also took the time to admonish him for wasting the court's time with frivolous claims. My client was awarded costs, meaning that Kevin's ill-considered attempt to strong-arm my client into paying more than was owed would end up costing him dearly. It was a rare, gratifying moment for me. Though I spend most of my professional life ensuring that situations like these never arise, it was undeniably satisfying to see justice served so cleanly. The law, after all, is meant to protect both parties in a business relationship. Kevin tried to manipulate the system and rewrite an agreement that had never been granted to him, but in the end, he walked away with nothing but a judicial reprimand. For my client, it was a relief and a vindication. For me, it was a reminder that even if I spend most of my time behind a desk, ensuring everything is done by the book, I still have the skill, and occasionally the pleasure, to step into a courtroom and set the record straight when someone tries to pull a fast